The judge in the trial of Bubacarr Keita, accused of raping a minor, could be left to decide whether the divorce of a witness could be discussed after state attorneys enjoined the court against it. Alassane Job quickly tackled Bubacarr Keita's lawyer Lamin S. Camara after the latter brought the divorce of Keita's ex-wife into the mix at the return of the trial on Wednesday at the High Court in Bundung. Objection: the state attorney quickly dissented when Camara asked the witness if the first thing that happened on November 6, 2019 in the house was her being granted a divorce and then her later reporting the matter of Keita falling on her sister to the police for the very first time. The witness had earlier said she could not remember what really happened in the house she was living in on November 6, 2019. She then later testified it was the day she lodged a complaint at the police for the first time. This was after this piece of event was presented to her by the defense lawyer Lamin Camara. On the issue of her divorce, the state attorney asked the court not to allow that question or anything regarding her divorce or alleged divorce. My lord, that question as to whether she was divorced or not is irrelevant, and the issue of her divorce is not before this honorable court, and it is not something that she ever mentioned in her examination in chief, the state attorney Alassane Job insisted. It is therefore not an issue, and cross-examination should be confined through the witness's testimony in chief. We therefore urge this honorable court, pursuant to Section 3 of the Evidence Act and the above quoted authority from the author, not to allow that question and anything regarding her divorce or alleged divorce. He insisted further. The State Council had initially referred the court to page 221 of Law Evidence book written by the current Chief Justice Hassan B. Jallow, where the legal mind argued that a witness is obliged to be questioned by the opposite party at the conclusion of her evidence in chief to challenge and test the veracity of the witness's assertions, whether of fact or of admissible opinion. He further stated that relevant is still the test of the validity of the question the State Council had also stated. The defense lawyer Lamin Camara, when asked by the judge to respond to the State Council's argument, said his objection was totally misconceived. My lord, I am convinced that the objection of my learned friend is totally misconceived, Camara said. He is expected to elaborate when the case resumes on Thursday. When the trial resumed on Wednesday, the defense lawyer began questioning the witness by first showing her a statement she wrote when she reported the matter to the police for the first time. Did you write everything you said to the court in that statement? Camara asked the witness. In replying, the witness said, no, it's not everything, because when I went to the police station, they asked me why I went there, and I explained it to them. Are you telling this court that what you told the court in your evidence in chief in connection with this case is not why you went to the police station? Camara said in a follow-up question. The witness responded that the issue of Keita falling on her sister was what took her to the police station, and they asked her, and she explained to them what happened on that day. So why did you not tell them what happened? A curious Camara asked. When I came to the court, I realized it's a platform where you can say all that you want to say. That's why I said what I wanted to say, the witness replied. The witness then said what the police asked her was what she told them at that time. When the defense lawyer asked her again if she didn't believe, the police station availed her the platform to tell them everything she wanted to say in connection with the matter. Because that was how they asked me. If they had asked me the way you asked me, I would have explained everything to them, the witness said. Everything you said in your evidence in chief on the pregnancy of the complainant is what you were told either by her, your mother, or a third party, the defense lawyer probed. The witness in replying said that's how she came to know it, because she was not there when Keita was falling on her sister. Questioning the witness further, Camara told the witness she had said in her testimony her sister had collapsed twice in school, and if that was true at all. Yes, the witness said. And then she said this happened when the complainant was living in the same house as herself and her ex-husband when the lawyer inquired about where she lived at that time. The witness said she did not investigate the cause of her sister's collapse in school when the defense lawyer asked her whether she medically investigated the cause of the collapse as an experienced mother. I did not investigate it because a lot of kids were collapsing in the school at that time, the witness said. And for 21 weeks, in your own words and in your statement, you did not notice that the complainant was pregnant while under your roof, allegedly. Is that what you are telling the court? Camara asked the witness. I did not know, I did not suspect it, and I did not pay attention to it, the witness replied. Wednesday's session also saw the state's lawyer express concern over her witness being constantly reminded of her oath to speak just the truth. My Lord, we are a bit concerned here because from the last sitting also, the court reminded the witness again that she was under oath. She is not a child, she is an adult. She has already sworn to tell the truth before this honorable court. She has already answered the question. With all due respect, I don't understand the fact that she is being reminded again because she has already sworn. Alassane Jobe complained when the judge told the witness she was under oath and should please answer the questions posed to her if she knew them. The judge said it was contingent upon the court to remind the witness of her oath to speak just the truth.